So good morning. It is a great pleasure to start the second debate of this session. First of all, I would like to thank the Miami International Arbitration Society for the invitation to be moderating this interesting debate. As you know, the debate that will take place now is, should Latin America follow Europeans' lead to create an investment court with an appellate recourse? That is the topic that has been assigned to this session. I would like to introduce our speakers in this session.
I don't know.
First of all,
I don't know if they can hear you, Klaus.
can you hear me? No. Now it's better?
Yes.
Okay, sorry. Okay, so the topic of this second session or this second debate is, should Latin America follow Europeans' lead to create an investment court with an appellate recourse? That's the topic, and to our right we have the proponents in favor of an investment court such as the European system. And on our left hand, you have those that propose continuing with the investor-state arbitration as traditionally contemplated in most VATs and other free trade agreements and the traditional method that we have used so far. I will briefly introduce our speakers at this session. Claudia Frutos is a managing partner of the DC office of Curtis. She's a former counsel of Exit. Claudia has practiced on this field extensively. She has experience in international law matters, investor-state arbitration, international commercial arbitration as well. We have Gaela Gehring Flores, a partner in Allen Overy. Gaela is a partner in the international arbitration practice of the firm. She has decades of experience in this type of disputes. Third, on our left, we have Silvia Marchilli, a partner at the White & Case offices in Miami and in Houston. Silvia focuses on complex international arbitration cases involving investment arbitration and commercial claims. She handles international arbitration and litigation matters involving Latin America and Africa and a variety of sectors, including gas, power, infrastructure, mining, transportation. As well, we have Grant Hennessian, independent arbitrator. Grant is an independent arbitrator in New York, specializing in international investor-state arbitration and complex commercial disputes. Grant has acted as arbitrator and counsel in a wide range of commercial and treaty disputes arising under the laws of many common law and civil law countries and public international law. Prior to 2020, he was a partner at the Baker McKenzie firm, where he practiced for more than 33 years. Going to the topic of our debate today, investment arbitration has basically been contemplated by VATs, by free trade agreements, but as well, the consent of states to go to investor-state arbitration has been given through internal laws, and as well, public contracts that include a clause that disputes may be resolved through investor-state arbitration. Those mechanisms have been created in order to promote investment, mainly in developing countries, but as well, they are contemplated in treaties in developed regions such as Europe or the NAFTA area. Usually, they protect investors from capital exporting countries in order to be treated in a fair and an equitable manner, and as well that in order to protect them against indirect or direct expropriation. A criticism has arisen in the last 20 years with the system of investor-state arbitration. Criticism goes that often it says that it's biased in favor of investors, that there's no certainty, that the decisions are sometimes contradictory. There's no an appellate body in order to decide errors and mistakes in those decisions. And there have been some trends in order to create either a court through a multilateral agreement where disputes will be heard by permanent court with the complexity of having to have an agreement among all countries of the world in order to create that court, how to finance that court, and that has been an idea. But the other model that has been followed by Europe, which has established a system of a court system which is contemplated mainly in the agreements between the European Union in the agreements between the European Union with Canada, with Mexico, with Vietnam, among other treaties that contemplate this court system. And the idea of the debate today is to see whether the better method is the traditional investor-state arbitration, which we all know, as opposed to this new system which has been created by a system by the European Union. Of course, there are many other ideas and many other projects, but the topic that we'll deal with today is, should Latin America follow Europeans' lead to create an independent court with an appellate resource? Such, obviously, the title of our discussion today implies that we're talking of a style court as contemplated by the European Union. Of course, that system as well has been criticized by many, and of course it has its own problems. And but today the idea is to debate which is the better system. It's very important to clarify that the roles that have been assigned to the speakers today was randomly, so it does not mean that anyone represents their own views over the topic or their firm's views. So I make this clarification so nobody believes that Claudia wants to change heads and stop doing investor arbitration, or that Gaela is pushing the European model. It's only for the purposes of having a practical exercise of debating these ideas, and so no role should be attributed to the author of the position they will be defending. So with this clarification, the idea is that we'll have a first opening statement of 15 minutes by Claudia Frutos, stating in favor of an investment court. Then, right after that, we'll have an opening statement against an investment court presented by Celia Marchilli. Then we'll have a rebuttal of 10 minutes by Gaela Gehring, and then a response of another 10 minutes by Grant Hanessian. And then we'll have, after that, 10 minutes time for questions from a student to each side of the table. And then after that, we'll open the questions to the public in general. And at the end of the session, we'll have a vote for either one system or the other. And then we'll see what the result is of the opinion of the whole attendance to this session. So with this, and the idea is I will be asking questions if during their presentations or challenging the positions of either side. So I would first start with Claudia Frutos, please. Claudia.
Thank you, Mr. President. Before I start, I just want to apologize for my voice. I can guarantee you that I was not partying last night. Too much is happening in Miami, and arbitration. So I was at the ICC, the middle of this week, meeting with so many good friends and colleagues that I haven't seen for 2-3 years almost. But so I will try my best with my voice. Good morning, Mr. President. Good morning, my dear colleagues on the other side of the table. Mr. President, this morning we are going to be discussing one of the most important topics if we want to save ISDS system in Latin America. And I am not exaggerating when I say to save ISDS in Latin America. My colleague Gaela Gehring Flores and I submit to you and to this lovely audience that the only way to save the system in Latin America is for Latin America to create its own regional investment court with an appellate body. There are several important reasons for my words, but before I discuss them, let me give you first a little bit of a background about this region and why it makes sense this issue especially be relevant. When comparing ICSID case law by region, investment arbitrations against Latin American states represent the largest shares of cases. For example, out of 68 cases registered by ICSID in fiscal year 2022, 24 cases were against Latin American states. The numbers were very similar in the prior year. In 2021, 24 out of 66 cases registered were against Latin American states. We all know that ISDS system in Latin America is experiencing a crisis of legitimacy. As you probably remember, in recent years, Venezuela, Bolivia, and Ecuador denounced the ICSID Convention. And although Ecuador has now rejoined ICSID, it has not concluded any bilateral investment treaties after it decided to terminate them all. Mexico, one of the largest economies in Latin America, also decided to terminate NAFTA and negotiate a new treaty with the United States and Canada that contains substantial differences from NAFTA, among them a more limited ISDS mechanism to be used in case of disputes under that agreement. Brazil, the largest country in Latin America, still has not referring investment dispute to ad hoc arbitral tribunals, but rather uses a mechanism of mediation and a state-to-state system to resolve those type of disputes. But Latin America should not be finger-pointed for its concerns vis-a-vis the current ISDS system and its criticisms against the legitimacy of the system. Other regions of the world are also questioning the legitimacy of the system. The European Union is not only denouncing ISDS for intra-disputes among their members, but are also denouncing the Energy Charter Treaty, and they are the main proponents of the creation of a permanent multilateral investment court. In fact, the new trade agreements concluded by the European Union with no EU countries call for investment court system to resolve disputes under those agreements. This is the case of the Canada-EU Comprehensive Economic and Trade Agreement, the EU-Mexico Global Agreement, EU-Singapore Investment Agreement, and the EU-Vietnam Investment Agreement. I think we can agree that ISDS provisions were created with the best of intentions to provide a neutral, independent, and efficient dispute settlement forum. This was supposed to overcome shortcomings of domestic litigation and diplomatic protection. However, we have seen plenty of evidence that the system has failed to achieve these goals. It is time to come up...
Sorry to interrupt you right there. Do you think that we can compare Europe integration with Latin American integration? Because Europe clearly has, all European countries have transferred power to the European Union, and the European Union has many rights where, regarding their agreements and their foreign trade with the rest of the world. Latin America, does it have an economical integration? And do you think the countries could create a similar court following the European example?
Thank you, Mr. President, for your very interesting and excellent question. From our perspective, that's not exactly our point, Mr. President. We are not debating here, submitting to you and to the audience that the court that we have envisioned for the Latin America is something exactly similar to what the court, what the EU members are discussing. Having said that, we do believe that there is such a crisis on the legitimacy of the system that Latin American countries will be better off by creating their own system. And please, as I will say in my debate, in my opening statement, Latin Americans have too many other choices to decide. I think this is one that is completely reasonable. Latin American countries could totally opt out of an investment dispute system, but this is not what we're arguing here. We're arguing here for a court that is a regional court to resolve investment dispute with Latin American cases.
Thank you.
I will continue. I was just saying that it is time to come up with a new system. There are already efforts in that direction, and I think, Mr. President, you mentioned some of those works related with the UNCITRAL Working Group 3, but that doesn't mean that Latin America could not work together to achieve a better result more quickly. I will now present to you 6 main advantages of a multilateral investment court with regard to Latin America. First, an investment court for Latin America will allow for the appointment of tenured, highly qualified judges who are obligated to comply with strict ethical standards. As we know, under the current ISDS regime, arbitrators are appointed by the parties. This introduces a risk that those party-appointed arbitrators will favor the party who appointed them. A lot has been written about this problem, and I am not going to repeat here all those arguments, but I will refresh your memories to the study prepared by Professor Albert Jan Vandenberg on dissenting opinions, and to the concerns identified by the UNCITRAL Working Group 3, inter alia, the lack of precise definitions of the applicable ethical requirements to arbitrators, the existence of potential conflict of interest, the qualifications required to serve as an arbitrator, and the impact of third-party funders and the independence and impartiality of arbitrators. A system of tenured judges elected and appointed to cases using an objective procedure will terminate with all these concerns. This system will also eliminate the issue of double hatting, where arbitrators continue to work as counsel and advance arguments on one side or the other in other ISDS arbitrations. Judges in an investment court will have one job and only one job: deciding the cases before them, without having to worry about protecting their ability to take an opposing position on behalf of a party in another case. More importantly, judges will have a public international law background, resolving one of the problems that we have in the system right now. A system of appointing qualified judges to a multilateral investment court will make it more likely that adjudicators are leading authorities in the field of international investment law, and this will bring us multiple benefits. It will guarantee a uniform interpretation and application of standard treaties. It will guarantee the correct approach to the interpretation of a state's conventional obligations, bearing in mind their subsequent practice and subsequent agreements. And we know that states want tribunals to pay attention to these issues. During the most recent sessions of UNCITRAL Working Group 3, the governments of Costa Rica, Peru, Israel, Japan, and Mexico made submissions indicated, and I quote, "The use of binding joint interpretations of treaty provisions by parties should be encouraged, and it should be ensured that such joint interpretation will be binding on the ISDS tribunals." A judge serving in a multilateral investment court will certainly be bound by such interpretations. This leads to the second advantage of a multilateral investment court for arbitration: consistency of jurisprudence.
Question.
Yes.
Do you think that those joint interpretations would not be followed by an arbitral tribunal?
Those joint could you please repeat your question?
If there is a joint interpretation by a party investor in the country, you think that that would not be followed by an arbitral?
As it is right now in the system?
Yes.
Well, Mr. President, you will be surprised that there are some tribunals that they have not respected that position. So there are certainly some tribunals in the system right now that they have paid attention to what the state, contracting states to those specific treaties, they had to say. But there are others that they have not. And this is my reference to that situation. We know that the inconsistency and unpredictability of awards issued by arbitral tribunal is one of the most criticized elements of ISDS. There is no status decisis, and so decisions can vary from case to case. Such differences arise not only between cases brought under different treaties, but also between almost identical cases under the same treaty. There are quite few examples of inconsistency in decisions involving Latin American countries. Let's address only one of them: the issue of the essential security clause in Article 11 of Argentina-US BIT and the customary law necessity defense set out in Article 25 of the ILI Articles on State Responsibility. The tribunals, both in Enron versus Argentina and SEMPRA versus Argentina, both under Argentina-US BIT, read Article 11 of the BIT in light of customary international law rules that dictate when a state may invoke a state of necessity defense. The tribunals failed to apply Article 11, which led the respective ad hoc annulment committees to annul the awards on those bases. But in LG&E versus Argentina, also brought under the US-Argentina BIT, the tribunal found that Article 11 is different from the customary international law necessity defense. In that case, the tribunal found that it is not a circumstance precluding wrongfulness, but rather a not precluded measure clause and excused Argentina from liability for a certain period determined by the tribunal. These unpredictability outcomes are bad for states and investors alike. The time has come for consistent decisions in ISDS, which on the state side is funded through millions of dollars from taxpayers. The system is in need of predictability and harmonization. An investment court for Latin American region could be regarded as a step to a coherent international investment body of jurisprudence and one that is decided by qualified experts in public international law. This in turn will prevent regulatory chill and guarantee the state's right to regulate. For instance, to protect human rights and the environment. Latin America is not strange to this kind of challenges to states' regulatory powers. We can cite so many cases in this respect, such as Philip Morris versus Argentina, Bear Creek versus Peru, Infinito Gold versus Costa Rica, and I could go on and on. The third advantage of an investment court in Latin America is to provide regional balance and gender representation. I think we can all agree that it's a good thing to have diversity of perspectives among the qualified adjudicators who are deciding these high-stake cases. In the current ISDS system, there are surprisingly few appointments of arbitrators from Latin America, considering how many cases are against Latin American respondents. Of the cases registered by ICSID in 2022, only 20% of arbitrators were nationals from Latin American states. And there are very few women, again, only 24% of these cases registered by ICSID in 2022. A multilateral investment court in Latin America could achieve the goals of adequate regional and gender representation in investor-state dispute resolution. The fourth advantage is increased transparency and ultimately increased legitimacy of the dispute settlement mechanism. I'm not saying anything new when I say that another common criticism of the current ISDS system is the lack of transparency, where the public often doesn't know about these cases that taxpayers are funding and that they might impact in issues of national policy. A multilateral investment court in Latin America could solve this problem. For example, such a court could adopt the Mauritius Convention with aim to achieve a uniform approach to transparency in ISDS. Such a court could also standardize and make accessible the role of amicus curiae in ISDS. And we know that this has been an especially important for Latin American countries. NGOs and international organizations are particularly known for their applications to participate as amicus curiae in ISDS concerning Latin American states, mainly due to topics of public interest under discussion in those cases. I can cite some of those cases just as examples: Philip Morris versus Uruguay, Suez versus Argentina, Bear Creek versus Peru, Aguas del Tonari. Some of this tribunal, in those cases, rejected the involvement of amicus curiae, while others accepted their involvement. A multilateral investment court will standardize the process and apply uniform criteria to all voices with relevant submissions to consider while deciding a dispute that involves topics of public interest.
Sorry, Ms. Frutos, I think your time is over.
Mr. President, I didn't want to interrupt you when you were describing the procedural order, but actually you gave us 20 minutes to each party to present our openings, and I don't think that the time that we use in our questions should be penalized. This party to finish its opening statement.
You have 1 minute.
Thank you, Mr. President. If that is the case, let me tell you that the fifth advantage is a more efficient and effective management of cases. We all know that investor-state arbitrations are expensive, involving the cost of counsel, expert translators, administrators, etc. A more streamlined process will reduce the costs spent by taxpayers and claimants and respondents alike. What we suggest is the staff at the Secretariat of this court could assist judges with legal research and preparations of their decisions, and that the Secretariat could take position on important issues that are currently up to discretion of each tribunal, such as whether or not secretaries of tribunal should assist with drafting awards, for example. The sixth argument, Mr. President, and this is my last one, is to improve the access to justice to an appellate mechanism. Many Latin Americans have the experience of requesting annulment of ICSID decisions and finding that committees may strongly criticize awards but decline to annul them. And this is due in part for the strict grounds of annulment set forth in Article 52 of the ICSID Convention. We have heard about proposals by the European Union that we should analyze carefully. Taken all together, all of these advantages speak to one single goal: rehabilitating the consistency and legitimacy of the ISDS. Let's not forget that ISDS system is the result of the will of the states to waive their sovereign right to adjudicate investment disputes before their national courts. Latin American countries could adopt other solutions to address the legitimacy of ISDS. They could say no to an international system to resolve investment disputes. They could refer disputes to a state-to-state system, or they could agree to the establishment of a regional multilateral investment court. We believe, Mr. President, that the latter is the most reasonable way to save the ISDS system in the region. And with this, Mr. President, I conclude my opening remarks.
Thank you very much.
Thank you.
Let me see, Marcelli, please.
Thank you. In 1986, the largest and most tragic accident in the history of NASA occurred, and it was a result of groupthink. Groupthink is a mode of thinking in which individual members of a small cohesive group tend to accept a viewpoint or conclusion that represent a perceived group consensus, whether or not the group members believe it to be valid, correct, or optimal. And that leads to terrible results. And I would submit to you that to the extent that we do need to engage in any so-called system reform, we haven't even decided to engage in that effort, the proposal would be a very good example of that group thinking. And in defending our position, I will frame my points in answering two main questions. First one being, what are we trying to fix? What concerns are we trying to assuage with a multilateral investment court? And does the proposal really address that, those concerns? And then a look into the future and how it actually could potentially land in LATAM. And I'll try to address most of the points that our colleagues just mentioned. And in terms of those concerns, right, we are discussing a very specific proposal to solve what is considered to be a series of concerns in connection with the system. One being, for example, transparency. Well, first of all, that's an issue that can be properly solved through treaty drafting. As we have seen, many of the latest generations of treaties do provide for transparency. There's an effort by ICSID, as Gonzalo, I can call you just for first name, as my colleague said, explained to us earlier today. And to be honest, when it comes to Latin America, we don't even need to think about a hypothetical initiative for a regional court. And that is because back in 2009, that initiative existed. It was called ALBA and UNASUR. And the proposition was spearheaded by Venezuela, Bolivia, and other countries to do precisely this. Evidently has not happened, but I would submit to you, let's look at what happened in reality. Venezuela. That was one of the main countries proposing that idea. Bolivia. So, and I'm tying back this to the transparency point. Those countries continued. Yes.
Latin America has changed recently dramatically, and we'll have to see what happens to Brazil. But I think most of the countries have gone to the far left or left. So
And that,
what do you
let
think
me,
about that?
I'll tell you in the coffee break what I think about that in general, but with respect to this specific issue, I would say that let's take a look at what Bolivia did. Apart from terminating treaties, it concluded commercial arbitration clauses in specific contracts. It continued to arbitrate. Just in the secluded context of commercial arbitration. Ecuador, same thing. They began to execute contracts with UNCITRAL clauses with Santiago seat. So that, I think, speaks to how candid that interest for transparency is. Let's take another example, the quest, and this one is particularly close to my heart, as we were commenting just a moment ago, the quest for certainty. I have to say that I find that ironic, being a regular claimant for counsel for claimant to listen to these quest for certainty, because inevitably, in every single case that I've argued, I have heard the argument, well, things change. There are new laws. You cannot petrify the legal regime. So again, I would submit that that interest for uniformity and predictability and consistency, I have a hard time believing it's the real motivation behind this. And we're, again, talking about non sequiturs. There's the gap between the concerns and the solution, and there's also how the solution, even hypothetically, would address those concerns. And having a court, a permanent court, and we can discuss the details, but assuming that there's some sort of system whereby for each specific case you select a few members, well, that does not guarantee certainty and uniformity either, unless we are assuming that all of those members will have a clear mandate to take a very specific position on every single of the most critical issues and with respect to investment arbitration. And going to another point that our colleagues mentioned, which is that arbitrators in the current system favor parties who appoint them. I would say that that same logic would apply to a court, which would be entirely appointed by states. So again, I think that at the core of the proposal is just simply restricting protections to investors and tilting the balance clearly in favor of states over investors. And I'll speak to a few points on the LATAM-specific jurisdictions that were mentioned at the beginning. The statistics that shows that LATAM countries are greatly involved in, or proportionally much more involved in investment treaty cases, and especially thanks to the transparency index that allows us to have those statistics, that shows it works. It doesn't show that there's a problem. And of course, the question that follow would be, well, that means that Latin American states are dealing with a situation in which they're unfavorably treated. Well, then you look at the next chart, which has the statistic of the outcomes of the cases. And there you will find that out of all the cases that are filed, about half are discontinued, right? So we're talking about 50%. Of that 50% that makes it to some sort of decision, there is an exact even split. And I think that in the last one, there's almost a 1% split in favor of states. So again, what are we really trying to do?
Can you compare that statistic with the worldwide statistics in terms of how many cases claimants prevail in international arbitration worldwide? Maybe our friends from
I guess my coordinator is ready to answer that question, but
I think it's 30%, if I'm not mistaken.
I've never seen any statistic that would show any bias or any systematic favoring of investors. And Grant here is pointing me to 28% number. The spin site, he'll be able to tell us later.
28 is 28.
Exactly. And then, a few examples of Mexico amending NAFTA. And of course, that's through the USMCA. Well, that's a solution. If states have an issue with respect to their obligations vis-a-vis investors, they're very well equipped to address any such concern by amending their treaties. And Brazil is the one example that in this type of context everyone mentions. Well, not every country in Latin America is Brazil. Brazil is such a big economy that maybe it has more leverage when it comes to deciding what their position is with respect to investment protection. But a couple of additional thoughts there. One, what would have the Bradford scenario look like? Had it signed investment arbitration agreements, maybe it would have received more investment. And second, the notion of the alternative that it would be, if we do not do this reform, the system will disappear. Well, I would submit that the system would disappear if we implement the reform. And it will be simply the case, as it was with ALBA and UNASUR, that any such initiative like that would not be used. And what would happen with that? Is it my position that investment would never, ever flow for investment to any of those jurisdictions? No. But let's talk about what type of investment, under which conditions. Are you going to receive riskier capital that will try to recover their investment more promptly under more favorable conditions at the expense of the population? Cutting corners when it comes to, for example, environmental issues? And again, reality shows that in those jurisdictions that have tried to avoid being part of the system, they ended up, in any case, executing agreements that did provide for arbitration, just a different type of arbitration. And we have not only the examples that I've given, but others in which it's a bit of a trip to the past, in the sense that we now have jurisdictions that are executing contracts with big companies that have arbitration clauses, no transparency, et cetera, and incorporate principles of international law, and specifically FET, for example. So you end up with a privatized treaty protection in a contract. That's how reality and the market would react. And while that may be very suitable for that specific company, it means that for other investors that have less leverage, they will not be afforded that. And perhaps a couple of points before I finished. And it is, again, the disconnect between the concerns and the alleged solutions, what it would be in the case of Latin America. And for those who think that this will be a part of an evolution or a growth, I every time I'm having a discussion of this, I think of a short story by Cortázar that was called Progreso era el de antes, or Progress was better before. And he tells a story of transportation, but going backwards. So he says, at the beginning there were planes, they were fast, but they polluted a lot, so we went back to trains, and so on until he gets to just walking. And I would think that the so-called evolution for a system reform as proposed will be that and not really a move forward. Thank you.
Thank you. Then it's the turn of the rebuttal by Gaila Gehring. So please, Gaila, if you can.
Thank you,
answer.
Mr. President, learned colleagues. Thank you for everyone being here today. And I would certainly repeat the refrain that this is for academic purposes. I am putting on my devil's advocate hat, if you may. But here goes. My learned colleague mentioned groupthink. This is quite the opposite of that, frankly. We're asking you to think outside the box of the past 2 decades where we've been. The proposition mentions Europe, yes. But the proposition doesn't say that we take whatever Europe is doing hook, line, and sinker. No. No. Latin America cannot do that, should not do that. Latin America is not Europe, as the tribunal president mentioned. We don't have an economic or political union of Latin America, and frankly, the notion that we would adopt everything that Europe has thought of is, frankly, rather patronizing, among other things. But why do we need to think outside the box and not engage in groupthink and not rest on the laurels of the system in which we've been in for the past 2 decades? It's because we do have a system in crisis. It's time. It is time to acknowledge this. Questions, serious questions of transparency. Yes, there are Latin American countries who are including dispute resolution clauses in their contracts, and retreating into secrecy is the answer to simply keep that secrecy going in the current system? Or should we look for something else? Should we look for a solution that actually brings things out into the light? Consistency and predictability of decisions. I'll get to that in a moment, but I think you all know what's coming there. Independence of arbitrators. All around us. We all practice here. There's an issue of double hatting which has finally come to a head, and you can see many of us leaving the ranks of counsel to go be independent arbitrators, right? Why would that be? Is that because double hatting isn't a problem? No, it is. It is. And this is one way in the current system for that problem to be addressed. But we could offer a permanent solution to that problem. We could take all those extremely experienced and talented former practitioners who are now independent arbitrators and make them full-time judges. What's the problem with that? We entrust them with our cases now. What's the problem with that? And the assumption that states, and only states, would appoint these judges to a permanent court is incorrect. Again, we're not following Europe's model. We're not doing exactly what they do. This is our chance to do it right. We would clearly involve all stakeholders in the decision of appointing judges. Why wouldn't we? Because, and as the president mentioned, we have right now the traditional system of resolution of investment disputes. Why was that system created in the first place? It's because countries want to encourage foreign investment. What state would not be intelligent enough to appoint judges that would be a part of the system that encourages foreign investment? If you don't, no investor is going to use that system. Why would you create a system that no one would use? I would submit that we would not create such a system.
So one question, if as well the population would participate in appointing the judges, is that the chambers of commerce? In Mexico, there are maybe 200. So who would appoint those judges on the private side?
I believe that there would be a commission of the stakeholders involved. It could certainly involve chambers of commerce and representatives of the state, and they could come up with a consensus of the judges to be appointed to this tribunal. I do think that it would have to be required that these judges have.
So you believe the European system is not working, and that the Europeans only appoint the judges?
Well, I mean, we haven't really seen it work, have we? But I am saying that there's no reason why Latin America would follow that particular lead. I think Latin America would need to do it correctly, and it would want to do it correctly, to be in this traditional system of actually encouraging investment and providing a stable system of resolving any investment disputes that come before it. So, should Latin America follow Europe's lead in attempting to get ahead of this storm of legitimacy? Absolutely yes. Business, investment needs certainty, predictability, finality. Can we possibly say with a straight face right now that our current system can offer investors anything remotely close to certainty, predictability, and finality? Let's just raise the concept of fair and equitable treatment, shall we? Right. Let's face it, we have no standard, no mooring post whatsoever. FET is a dumpster fire, and the blaze from that fire can be seen from miles away. How would your client and investor ever know for sure if they actually have a strong FET claim? How? By a list of adjectives that are given in a variety of investment decisions? Manifest, arbitrary, I don't know. The list goes on and on. But you cannot deny that investors have no place to predict, to be certain, to be final in FET land. So, would you prefer to have a permanent court where investors could go and get a predictable answer and be certain in their investments? Or would you prefer to just roll the dice and see if this tribunal thinks that whatever the state did under whatever administration is fair or equitable? Unless you think that the I know it when I see it standard that we have right now is an acceptable standard, then I think we need to, again, look outside the box. And with respect to this, let me just submit that there are two different concepts of time in traditional thinking: chronos and kairos. Chronos is the concept of time that we experience in our bodies, that we experience physically. It's time moving forward, right? It's kind of the way we just think about time generally. Kairos is a different concept of time. Kairos is a disruptor. Kairos is something that happens in your life that creates a pivot point, a point where we are fully in the moment. And in fact, it's been described historically as the point at which an archer opens up and lets the arrow go so that it can actually hit the target. I will submit to you that right now, we are in, or we could be in, a moment of kairos, not chronos. We can see this crisis coming from far away. Why not be in the moment? Accept the fact that we are in a system of crisis. We know that investment arbitration, as we know it, is coming to an end. And if anything, the European Union's experience right now, their proposition of the Multilateral Investment Court, ACMEA, Comstroy, intra-EU BITS, that's the fire in the distance. We're watching this edifice inexorably crumble. So, and it might work. It might work for all of us right now. Because, we're not Europe, we're Latin America. So we keep going with our daily, quotidian, chronos lives. We're counsel in some cases, we're arbitrators in some cases. We keep going. But does that mean that we should just keep going as we've always been and ostrich our way out of this until we don't have this system anymore? Or should we actually engage with the moment and be in the moment and let that arrow go and work? Engage in very hard work to find a resolution and a system that investors deserve, that states deserve, so that they can finally find the finality, predictability, certainty that they need. Why not create a system that doesn't just work some of the time, but a system that works all of the time? I think we're up to it. I think we are now seasoned enough. I think we are intelligent enough. And I think we can do it right for Latin America and for all the stakeholders involved. Thank you.
Thank you. Grant Genesian will now give the final rebuttal.
Thank you, Mr. President. I may come back to Kuros and Kronos and dumpster fires and the rest, but I want to start by thanking the Miami International Arbitration Society, Don Hayden, Louis O'Naughton, and as somebody who grew up in South Florida and who spent a lot of time in my youth at the old Orange Bowl, banging on the aluminum flooring in support of the university's football team, I do want to say that it's really wonderful to be here and to see this fantastic growth of the Miami arbitration community and so much that has happened here at the law school, and that Miami now has become an international center for international arbitration education. It's something that's particularly pleasing to me. Well, Claudia said that the only way to save ISDS in Latin America is to create an investment court, and we have the apocalyptic vision of Gaia. I have a more pedestrian view of this, I have to say. The legitimacy argument, as I understand it, is that three independent people are deciding matters of tremendous social, economic meaning for the states involved, and that there's something illegitimate about that. So the solution then is to take arbitrators that are said to be biased in front of the investors, and reminded me of being at a Vismut court thing here, handing this to my colleague, but in a system where the investors are prevailing 28% of the time, to get rid of the way that we're selecting the arbitrators and to have the states select the decision makers. I understand there's a commission that's just been proposed among the arrows flying and everything else that we've heard in the last few minutes, but the European system is that the states appoint the arbitrators. In this law school, about 10 years ago, Jan Paulsen delivered an address that got a lot of attention and supported by some research from Professor Vanderberg, who also has taught here, arguing against the parties' traditional rights to appoint their own arbitrators. And they proposed, Professors Paulsen and Vanderberg, that arbitrators should be appointed jointly by the parties or by arbitration institutions. This was about 10 years ago. Since that time, there have been thousands upon thousands of commercial arbitration tribunals appointed, and none of the institutions have taken up on this argument. Now, why is that? Why do parties not trust even the best institutions, and many of us were at the ICC conference and commission meeting these last couple of days, why do parties not trust the best institutions to appoint their arbitrators? And the answer came from Johnny Vider, also extremely distinguished international arbitration practitioner and thought leader. He's responding to Professors Paulson and Vanderberg, and he said it's because the party appointment gives the parties a sense of ownership in the process. It's consensual, and it gives both sides some feeling of ownership, of participation and ownership. The investment court just does away with that. It strips the ownership from half of the participants. That's the point. That's said to be the point. Presently, the states control half the appointments in investment treaty cases. They appoint their own arbitrator and they participate in the selection of the chair. Or they participate in 2/3 of the appointments, because if the parties can agree on the chair, then ICSID appoints the chair in an ICSID case, and ICSID appoints the chair from a list of arbitrators proposed by states. So currently, states have between 1/2 and 2/3 of the ownership, if I can put it that way, with respect to the selection of arbitrators.
Grant, do you see the tendency that more and more chairmen are appointed, or our parties try to appoint the chairmen?
Yes, and precisely because they don't, thank you for the question, precisely because they don't want the institution to do it. They want the ownership. They want the sense of ownership. It's important for their own constituencies, be it the state constituency or the investor constituency. This legitimacy issue, which we've heard mentioned a couple of times, is not about the way the tribunals are appointed. The issue is that states have agreed to treaties that provide for certain protections, and tribunals have found that states have violated those protections. Why? Because the states have violated those protections. They've taken things without paying for them. They've acted unfairly, inequitably, discriminatorily. And the tribunals find that there needs to be a remedy. But instead of dealing with the text, instead of dealing with the FET dumpster fire, instead of defining FET better, let's just throw out the decision makers and replace them with our own decision makers, who will, the states believe, apparently, will enforce these in a way that doesn't require that they be penalized when they act unfairly or inequitably or discriminatorily or take things without paying for them. This does not lead to greater legitimacy. This leads to less legitimacy. And this is further to Sylvia's point, I think her main point, ICSID was created 60 years ago, and I speak under the control here of Gonzalo. I don't want to speak too much about the history here, given that the history is sitting in a room in a big, significant way. To depoliticize investment disputes. That was the whole idea, that you'd have neutral decision makers that would decide the case rather than a national judge grounded in politics or policies of a host state. So the states here should be careful for what they wish for, I think. And the best example, I think, of this is the appellate body of the World Trade Organization, which is a standing court. There are decisions which have been consistent, but they've been consistent in a way that states don't like. States are saying, oh, you're impinging on our sovereignty here. Who are you guys, even though we appointed you, who are you guys to tell us what the law is and issue decisions that affect our countries, our societies in such fundamental ways? So what has happened to the appellate body of the WTO? It's been being defunded and unparticipated. The U.S. has withdrawn from it, and it is on the verge of collapse. It may collapse. And I submit to you, this is exactly what will happen if an investment court is created somehow, although it's really not clear how, when, who, what, where, any of the details of this, how this would work, is the states wouldn't have this legitimacy argument anymore. They can't say there are three independent guys. We don't know who this von Woopser is to tell us what to do. And then what will they do? They'd say, okay, well, we don't participate at all. If the investors don't like the court, what will they do? They will go back to state espousal of claims, which is where this all began. And we know from what is happening in the world today, sadly, that states don't stop at diplomatic espousal of the claims. They have other means at their disposal, as they have had for centuries. And these means are extraordinarily damaging to the peace and security of the entire world. So I think we should be careful about disturbing a mechanism which has worked fairly well. I mean, you know, if you sort of step back and think about where we all were 40 years ago. So you're setting aside a system that works reasonably well with something that has to be defined and negotiated, ratified, established, financed. And what are the precedents for this in Latin America? This is not Europe. There is not a European Union. There is no economic integration. And more than half of the population of South America is not participating in ICSID. I've lost track of my time a little bit, but I'm sure the president will cut me off when the time comes. And I just want to say one more word about
The
diversity.
proponents submit that the respondents have reached their time.
Let me.
Yeah, the president was tougher to
you have
us.
1
I'm
minute.
sorry.
I have 1 minute. All right. Okay.
1 minute.
I guess I do want to say, as I said in my notes, the way to deal with a dumpster fire is not to get rid of the fireman. You know, it's to have better fire safety, to change your text. I did want to say one word about diversity. It is a fact that that ICSID appoints twice as many women. I'm just focusing on women here than the states have in their appointments. There's data on this. Last year, the states appointed 22% of their appointments were women. The ICSID secretariat was 43%. So the idea that this investment court will in any way increase diversity, I think, is not borne out by the facts. There are, I would say, hundreds of people that have been given an opportunity to participate as arbitrators in these cases that would not have been given that opportunity otherwise, and would not if there somehow, some way, a Latin American investment court were able to come into effect. Okay, thank you.
Thank you very much. So with this, we have ended the meetings between the parties. So we open the questions to the students. So I don't know where the students are. Okay. Okay,
Good
please.
afternoon. Yeah, good afternoon. My name is Tatiana. I'm an international arbitration LLM student at the University of Miami. First of all, let me thank you for a very engaging debate and for the opportunity to be here. The question goes to Madam Garin Flores and Madam Fredus Peterson. Suppose we have this multilateral court that you're advocating for, and if we set up an appellate division, what would be the basis to divide the judges into, let's say, simple judges and appellate judges? And here I would like to quote the late Sir Eli Lauterbach. The mere fact that one person has been set in the position to pass judgment on the verdict of another does not give the second decision a greater quality than the first, end of quote.
Thank you for the question. I think we see today a difference between the type of arbitrator that is appointed to, for instance, annulment panels at ICSID versus the type of arbitrator that is appointed to first instance arbitration panels. So I guess I don't see that as being such a fraught challenge. I think in most domestic systems, in most domestic legal systems, you have judges who are appointed to first instance courts, judges who are appointed to appellate courts, and you look for the qualities that you want to find in the judges of each respective court. I certainly think that in the instance of the appellate court, you would want, again, I mean, I think we have people right here in the room. You would certainly want, from the people who you would consider appointing, you would want the pool of arbitrators who are currently being appointed to annulment panels. That in my mind is the answer to the question.
And I will add to that. I mean, I just found out that she wrote apparently a thesis on this topic, so she has the advantage on the answers. But I will say that to me, the discussion has to be between the nature of the arbitration. You have to depart from that. And I don't know from where you are quoting Sir Lotherpack. I had the pleasure to work with him at ICSID. I know one of the first cases that I did that, but I'm wondering whether he is commenting on commercial arbitration, because that's precisely my point. My point is I think that we have come up to a point where we need to divide. We need to divide between commercial arbitration and investment arbitration. I think both systems are mature enough now to really make that division. I do see that quote falling perfectly in commercial arbitration, but in investment arbitration, when you have regulatory power issues of the states, where you have public interests of the states, where you have citizens paying these investments, I think division needs to be different. And I would just say, and I don't have the answer, on how this system will look like, but I will think that probably the idea of why states are continuing wondering whether we should have an appellate mechanism. I mean, we discussed it, and now Gonzalo is laughing because we discussed it in ICSID long time ago, and Antonio Parra was walking on the corridors of ICSID with his draft paper about the appellate body, and it was not popular enough. Nobody wanted the appellate body. I want Antonio Parra now to talk about that topic again. But what I can tell you is that, in my opinion, what states are concerned is precisely, it goes together with harmonization, uniformity of the decisions, and the errors. What type of errors the appellate committee will be able to, to look into it. Of course, we're human beings, we're not perfect, but at the end of the day, I think when you talk about an appellate body for an investment system, you are talking about consistent harmonization, and the interests that they are behind. That's why I think it has to be different. Thank you.
Yeah, of course.
Just a brief comment on the analogy to the ICSID annulment mechanism. I think that that's really not a valid analogy, because precisely you, I would say, can afford some more creativity when appointing the committee members, precisely because of the very restrictive grounds for annulment. But if the proposal is so that the appellate court would be correcting errors of law, or would be actually dictating, because that's the underlying premise, right, to make it consistent, then that logic would not hold at all, right? I mean, it's a bit of too different of an animal to draw that analogy, and plus the fact that it's ad hoc, right?
Thank you, Silvia. Another question by a student, please.
Yes, another question. My name is Emanuela Martin. I'm also an LLM student. I would like to thank you and the first panel for this very insightful presentation. And I would like to address one question to Ms. Flores. I assure you there's no conspiration in that. But of course, your colleague, Ms. Peterson, can answer as well. So Ms. Flores, you said that Latin America shouldn't create an investment court just like the European Union did. You said that Latin America should do, that you should do it right, you should do it correctly. And I was wondering if you could be more specific and tell us what features of the current European investment court you find to be, let's say, less than ideal? And in this sense, what should Latin America do differently? Thank you in advance.
I think the main difference that I was pointing to was in particular who is, or the process for appointing judges. I don't think it's the correct tack to have the states and only the states appoint judges to a permanent court. Again, if this is a system that is encouraging foreign investment, you need to create a system that foreign investors will actually trust. You need to create a system that is inherently neutral and impartial. And if you don't create that system, then you will have this nice edifice that people kind of go by and nod and say, that's kind of pretty, but no one's going to go in. No one's going to use it. And more importantly, the whole reason for your creating this system, which was to encourage foreign investment, goes down the tubes. So why do that? That's kind of the, at least from my perspective, the biggest point of departure that I could see for creating a system for Latin America. Now, I think one of the things that none of us has mentioned thus far is that none of this is very tested. None of the details of anybody's proposal is particularly tested here. So what are we talking about? It's a very, very fair question. What about more details? And frankly, this debate certainly doesn't give us the opportunity to really dig down into the details. And it's something that, keeps me up at night, because one of my law professors at Georgetown would constantly have the refrain of, it's not the devil who's in the details, God is in the details. So, if we were to launch into something like this, if we were to try to solve, the current crisis of legitimacy, the current problems that we have, we would have to really get into the details. And that, that's a really good point. That is one detail that I've been able to draw out that I think must be addressed, and that's how and who these permanent judges are. But there's a lot more.
Please go ahead.
We have the European examples, though, and in those examples, the states have appointed the judges. I mean, the likelihood that Latin America or any region would be able to.
But are you saying that only big brothers can do it, Grant? We can also.
I'm saying.
I don't see the point.
There's a point. No, well, I guess I don't want to be anti-utopian. That's probably. So maybe I'll stop.
Let us dream a little bit.
But the topic, I think the question that was raised by the student was excellent, the first question, in terms of imagine if you leave the appointment to the governments in Latin America. We know how Latin America works. So you end up with you would end up with a list of a bunch of judges who are the friends of the Minister of Economy or the Minister of Foreign Affairs. So probably not the best judges. So,
but I will say, Klaus, I will say that now you have so many Latin American practitioners, that we have followed you, Klaus, on the path, and we have learned about arbitration, and we have learned about commercial arbitration, investment arbitration, international public law. I think I agree with you. There is that danger. And Sylvia mentioned, in her discussion about other attempts, to try to form this type of tribunals. But I wonder whether, with the proper systems, where, you will have the consensus and the discussions and the debates you could achieve something else. But I hear your point. It's a danger, yes.
Exit I mean, we have some good names on the lists of the governments. Some. many, Gonzalo, and many. I mean.
If I may, I think one interesting proposition with some sort of permanent court is that you could actually catch states in the moment when they have their treaty, when they have their investment treaty party hats on, as opposed to their litigant hats on. When a state is confronted with the challenge of who to appoint to a tribunal when they have a dispute facing them, well, they're going to appoint X person. But if you can erase the dispute, and if you can go back a bit and catch a party when they are negotiating or when they're in investment treaty negotiating mode, and they want to actually encourage foreign investment to their country, I think there's a higher likelihood that you would find judges appointed that investors would actually feel are neutral judges. So I think getting states to this different approach of pre-litigation, pre-dispute, and wanting to encourage foreign investment, and now that we have a more experienced investment arbitration bar, one would hope that that bar could certainly, protect the system, be part of this, I know, just newly proposed commission to nominate judges, but hey, give me a break. But I would hope it would work. The Gehring Flores Commission, there you go.
So I think we have only a few minutes left, so I would like to turn to our last part, which is the questions from the audience. So if somebody non-student has a question, please, of course.
Thanks. It's a question actually for Gaela or for anyone in the panel. I don't know if we're still playing the game. So, but Gaela, you mentioned
We're not playing the game with our answers.
Gaela, you mentioned that you describe investment arbitration as a roll of the dice, and this potential
In the context of FET.
court has been much more certain in the outcome of the potential decisions that this court would issue. And I wonder what's really the metric, what's the measure that that is the basis of this assumption?
The metric I am using to say that bringing an FET claim in an investment arbitration as a roll of the dice is, rather unfortunately for me, in my practice, I've actually had to do an extremely thorough review of every single FET decision and minimum standard of treatment decision. I have had the occasion to do this and create tables of these decisions. It's not fun. It's not fun, yeah. It doesn't have a very good end. There is no end. You create the table and you see, yeah. Juan is agreeing with me.
But can I interrupt you? Can I interrupt you here?
There's no standard. There's nothing there. There's no there.
They're clear. I mean, everybody who's worked in the field has their list of cases that you have to do that. And a court would be the same thing, and all courts are, it's the same. And they're fact specific. But one of the things that I wanted to just not leave on the table here is when you said, we know it when we see it, right? Okay, that quote, of course, is from a court. It's from the United States
Yes, it
Supreme
is.
Court talking about obscenity. There are certain things that are left vague and are dealt with in the, whether it's God or the devil, in the details and the facts of the case.
But that particular U.S. Supreme Court case is cited with notoriety, not with.
But there you have it, though. And in fact, the ball hasn't really advanced on that particular point. And I wonder, you know, and you do have treaties where the parties have gone to greater lengths to talk about this. And that's part of our point here is if the text is the problem, fix the text.
If you think that FET should be compared to pornography and the standards that we apply to pornography,
no.
then okay.
We agree.
It should be that vague. Okay.
Okay. Last question. Yes, please. Please. I don't know if you have a microphone or. I think some you will get a microphone.
Thank you. Thank you, Mauricio Gom. Brazil was mentioned a couple of times today. And by the way, today is election day in Brazil. And regardless who is going to win the election, which I can assure you is a very hot topic in Brazil, it won't change anything as far as investment state is concerned. Brazil has sort of a perception, assumption, or even a conclusion that the country does not need exit convention or BITs. Right or wrong, that is the reality. Actually, I think Claudia has mentioned mediation. That is a cooperation, facilitation, investment agreements. And they call for ombudsman and then sort of a joint committee between states, not between the investor, but the state of that investor and the hosting country. So the debate in the country may go more on whether Brazil should sign and ratify exit convention, for example, for the protection of Brazilian entities investing abroad, instead of going to a sort of a treaty planning. So that is just a footnote. There is no question. It's just a comment about the reality in Brazil. Thank you.
No, and you're right that the big countries in Brazil have becoming exporters of capital. I was really very surprised recently when I talked to the president of ICC Ecuador, when he told me Mexico is #1 investor in Ecuador, before the United States, before Europe, #1. So it's the trends have changed, and our friend Gonzalo can tell us about this. You see now countries that used to be countries receiving investment, such as Mexico, Brazil, but others in the region are now exporters of capital massively. And I think if our government, particularly in Mexico, continues with this policy, will be even more exporting capital. So there are new trends in the world which we had not imagined when we conceived the system. So thank you very much for your comment. And unless there's a final pressing question, okay, I think somebody was asked.
From an institutional standpoint, how could a court work in Latin America? The UNASUR was negotiated for multiple years, and it didn't come to an end. So how could be the institutional arrangement for financiation, like in practice? Could it be real to think about it?
I'm sorry, I didn't get, probably it was not very clear. I'm sorry. Maybe it's the volume of the microphone, sorry. I couldn't follow the question.
From an institutional standpoint, how could the negotiation of an agreement work. UNASUR was a failure. It was negotiated for multiple years. So one of the pressing issues was the financial matters. So how could you envisage this possibility from practice?
No, I think in the practical terms, I think negotiating a treaty, I mean, I'm not sure if I should answer the question, but if I think it would be extremely complicated to negotiate a treaty where you would create the Latin American Investment Court. I think from a practical perspective, extremely complicated. And there was a question on the chat which basically said if there's no economic structure such as Europe, and that was one of the questions I raised during our discussion this morning. It's very, very hard. So contemplating an investment treaty court, I think in practice is almost, I would say, impossible, particularly the way the region...
Move to challenge the arbitrator?
I second.
Yes, there will be a challenge, sorry. I accept the challenge.
Okay, who is our next president?
So I think to end the session, we have to make a vote.
Klaus is not voting.
I will not vote. I will not vote.
It's behind you.
Okay. I think the vote was before I made my comment, so. But I resigned. So really, I would like to take the opportunity to thank very much. I'm very impressed with MIAS. You have done a fantastic job. I had not been in a session before, and I'm very impressed with the university. When I entered, I said, I really would like to study again, or at least come to be a professor. Caroline has invited me, and I accept. I really was so impressed. I've never seen such a beautiful university. I congratulate you, and fantastic turnout. It's full. I mean, on a Saturday, Sunday, before starting the IBA, finishing the ICC, it really was really well organized. Thank you very much for having me here, and thank you very much for our panelists. I would ask you for a big applause because they did this fantastic.